first ban on abortion that starting tomorrow, July 1st, will ban abortion after the 12th week of pregnancy in most circumstances. And it will also put in place a host of new restrictions or barriers to care that providers and patients will have to navigate. We are also here today, as y'all know, Judge Eagles did issue a final order, a temporary restraining order in the lawsuit against Senate Bill 20. We are going to talk about that, in addition to talking more broadly about how we're all preparing for this law to finally take effect tomorrow. We have experts on the line to talk us through this and answer your questions. We have Peter Eam, who is an attorney with Planned Parenthood Federation of America. He was also one of the attorneys who was at the hearing on Wednesday in Greensboro, for folks who were there with us then. We also have Liz Barber on the line, who's an attorney with the ACLU of North Carolina. And we have Dr. Catherine Ferris on the line, who's the Chief Medical Officer for Planned Parenthood South Atlantic. Catherine Ferris will be our physician representative for our call today. So I know many of you have questions about what providers are seeing on the ground already and how we're preparing for tomorrow, and she'll be glad to speak to that. We are going to have those three folks give some opening remarks, and then I will be glad to open it up to questions. So for anyone who has a question, when we get to that point, please use the raise hand function at the bottom of your screen, and we'll do it the old-fashioned way. I will call on people, you can ask your question, and we will move down the line. Brian, I see you do have a question right off the bat. I will be glad to, do you still have a question, Brian? You can also use the Q&A function to chat me. Let me see. Brian, I have unmuted you.
Hey, thanks. Can you hear me okay there?
Yes. Hi, Brian.
Thanks for the time. Thanks for the question. Just really wanted to ask it because I know this is very important to lots of people, and we've got a little more than 10 hours to work with before this is implemented. Of the 14 different abortion clinics in North Carolina, if that number is still accurate today, how many of them will still be able to provide access to an abortion tomorrow? I know there's been talk of clinics not being able to once this bill is implemented. Can you just explain to people who might find this helpful, where can they get an abortion starting tomorrow?
Brian, thank you for that question. We'll be glad to talk about that later. If you don't mind, I'm going to start us out with the lawsuit and the temporary restraining order, and then we will move into the impact on patients. But thank you for that. Great. And with that, I'm going to turn it over to Peter Eam, who again is one of our attorneys at Planned Parenthood Federation of America. Peter?
Thanks, Molly, and thanks everyone for joining us. My name is Peter Eam, and I'm a staff attorney at Planned Parenthood Federation of America, and I'm one of the litigators in this case. In their eagerness to strip North Carolinians of their basic rights, the General Assembly passed SB 20, which is a shoddily written law that was riddled with unconstitutional inconsistencies and confusing contradictions. And the law would have made it even harder for clinicians and people seeking abortion to comply with already stringent and burdensome restrictions. After we brought this lawsuit, the legislature worked to clean up some of their mess by passing House Bill 190 this week. So most of our claims actually were no longer necessary for the court to address. The legislature didn't correct one provision in the law that left unclear whether providers can provide medication abortion to people at the very earliest stages of their pregnancies. We're grateful that Judge Eagles today granted our request to block that one part of the law on the ground that it's unconstitutionally vague, and that ensures much needed consistency for North Carolinians seeking abortion care, at least through July 14th. Under today's order, abortion providers can provide medication abortion to patients at very early stages in their pregnancy. And the order also clarifies that people can help others get out of state to receive legal abortion care after 12 weeks. Now, unfortunately, abortion will be banned after 12 weeks of gestational age in North Carolina, and that'll force people to travel out of state or carry pregnancies to term. I want to be clear that this is going to have devastating consequences for North Carolinians. But the judge's order will mitigate some of the harm that SB 20 will have on patients' lives once it takes effect tomorrow. This case continues, as does our work advocating for reproductive rights in North Carolina. I'm happy to take questions on the specifics of this case after everyone's remarks, but for now, I'll turn the call over back to Molly. Thanks.
Thank you, Peter. Okay, next we are going to hear from Liz Barber, who is an attorney with the ACLU of North Carolina.
Thank you, Molly.
You're welcome. Let me just fix your video and you are good to go.
Great. I'm Liz Barber. I use she, her pronouns, and I'm Senior Policy Counsel with the ACLU of North Carolina. And like Peter said, while we've been able both through a legislative fix that, to be clear, was forced by the lawsuit and by Judge Eagle's order that came down today, we have been able to address some of the uncertainties and impossibilities that were in SB 20. But quite frankly, we're just in a completely different world than we were just 53 weeks ago when Roe fell. And we saw bans getting passed and bans being implemented, especially throughout the Southeast. And we saw that the harm that they caused. And we feared that one day that would come to North Carolina and that harm would come to North Carolina. And sadly, we are at that time. And so we can no longer talk about this ban in the future. It is upon us. I spoke to a doctor just yesterday who already had to turn away 3 patients. And this was just yesterday because the law would be in effect after that 72-hour mandatory delay had passed. We in North Carolina have been deprived our basic rights by this dangerous and sweeping law. And this law will harm North Carolinians and people throughout the South who are having to travel further and further to get this basic health care or be forced to carry their pregnancy to term. Thanks, Molly.
Thank you, Liz. Next, we are going to bring up Dr. Catherine Ferris. She is the Chief Medical Officer of Planned Parenthood South Atlantic. She also is one of the abortion providers in North Carolina, and is able then to speak to many of the questions that I know y'all have about, what we're already seeing on the ground and what we are facing tomorrow. Catherine?
Thanks so much, Molly. As Molly said, my name is Dr. Catherine Ferris. I use she, her pronouns, and I am the Chief Medical Officer of Planned Parenthood South Atlantic and a proud abortion provider for over 2 decades. And I think the thing that I am feeling the most, and that most of my colleagues who provide this critical healthcare are feeling, is just the deep devastation caused by this sweeping ban. This will absolutely harm patients. Our patients are devastated, and the doctors who care for them are devastated. We already earlier this week have had to start navigating patients out of state, knowing that they would not be eligible for care tomorrow in North Carolina. And we are going to do everything we can to see every patient we can within the confines of this monstrous law, and to make sure that patients who can't get access here in North Carolina can find the safest place to receive the health care they desperately need.
Thank you, Dr. Ferris. Okay, I am now going to bring back, I'm going to bring back all of our panelists, y'all, Liz and Peter and Dr. Ferris, if y'all could all be with us for any questions. So Brian asked the first question right off the top. And Brian, please feel free to repeat your question in the Q&A, or we can ask it again. But to your question about whether or not we're aware of any clinics who will not be providing abortion care tomorrow, the answer is no. We are not aware of any. I can say that Planned Parenthood South Atlantic, we are ready. We've been working really hard over the last month to be able to comply with this law, and our providers and our staff have been working around the clock to make sure our health centers can stay open. So we're not aware of any, and yes, for everyone else with the question, there are 14 clinics in North Carolina. They are all concentrated in 9 different counties, which leads to the statistic that 91% of the counties in North Carolina do not have an abortion provider. That's still true today. 14 clinics. Okay, Brian, since we're on your question, I will kick it back to you to ask. Brian?
Thank you. I appreciate that. To be clear, I heard raise your hand for questions part. I didn't hear the first part of the opening remarks, so my apologies.
Okay.
So going to those, just to be clear on the new licensing requirements in this bill, will any of these 14 places be affected, or are y'all saying we believe all 14 will meet the standards of this new law and allowed to operate in perpetuity?
I can jump in and speak to at least Planned Parenthood South Atlantic. So as Molly said, all of our centers who normally provide abortion care on Saturdays will be open and seeing patients tomorrow. We've been preparing with in-person consents to meet that requirement of the law. What we don't know, Brian, is we don't know how the facility regulations are going to be rewritten. And that part of the law does not go into effect until October 1st. So we simply don't know what the facility requirements will be. And I think Peter or Liz might be able to speak a little bit more to the concerns we have around that. Since that part of the law isn't in effect yet, we are working under our current active facility licenses.
Excellent answer, Dr. Ferris. Thank you. And I want to just repeat this because I know there's been a lot of confusion about this, especially since the bill sponsors talked a lot about it during the legislative debate. There are no new clinic regulations in that sense in place right now. The North Carolina Medical Commission, I believe is the name, has until October 1st to revisit any regulations on abortion clinics. They have not done that yet. My understanding is that they will only meet one time between now and October 1st. And while Senate Bill 20 authorizes them to impose new regulations, they don't have to. So that is completely TBD. And really, until we know more, we really can't speculate about what kind of impact that would have on clinics because there's a lot of variables. So all of that kind of regulation thing, to say it plainly, that's not currently relevant. That's not in effect yet. Another clarifying point is that the requirement that anyone after 12 weeks of pregnancy must have their abortion in a hospital. So this would be people who fall into the narrow exception categories written into this law. Anyone beyond 12 weeks, the hospital mandate, we call it, that also does not go into effect until October 1st. I believe we mentioned that at the top, but I just want to repeat that. So between now and October 1st, those patients, should they fall under the exception categories and meet those requirements, they are able to still come to a clinic for their care. For example, a survivor of sexual assault between now and October 1st can still come to a Planned Parenthood health center if they are before, I believe it's 20 weeks of pregnancy. So that is also not into effect until October 1st. I know there's a lot of moving pieces here, so I appreciate the chance to be able to clarify. And I think we have a question from Kate Kelly with the New York Times that Dr. Ferris would like to speak to. Go ahead, Dr. Ferris.
Thanks. So Kate Kelly had asked some clarifying about what does this mean about whether or not a pregnancy has to be visible. So we are required to perform an ultrasound for all medication abortions. That is absolutely required, and it must occur at least 72 hours prior to the abortion. The language in the law as written stated that we must see a pregnancy within the uterus in order to perform a medication abortion. And standard medical practice, sometimes patients can get to us very early in their pregnancy. Many people cannot, but when they can, our standard practice is to evaluate the patient, make sure that medication abortion is reasonable and safe, and then go ahead and start the medication abortion process even if we cannot yet see the pregnancy because the patient is so early. The way the law is written, it does not allow us to do that. And that is the piece that the judge enjoined. So not whether or not we have to perform an ultrasound, but whether or not we have to see the pregnancy within the uterus before we can start a medication abortion process. And this is critically important for patient autonomy. It allows patients to choose the medical course that is best for them with their medical history, their own desires, and how they want to proceed with their abortion.
Thank you, Dr. Ferris. I saw in the chat another person wanted to confirm the number of clinics in North Carolina. There are 14. And again, if anyone needs more information on that, let us know. I also see a question from Kenneth Lee. Do you foresee any clinic closures because of this new law? Again, we cannot speculate on that at this point. To me, that question really speaks to the regulation, the extra regulations that may or may not happen, as we just discussed. So we really can't speculate on that. And really to emphasize here, the most important thing to know is that patients are going to be dramatically affected by this. In fact, they already are, as we said. And also healthcare providers are dramatically affected by this, even without any new regulations in place. Great. Brenna Flanagan with Port City Daily, hey there, has a question for us. Can you offer any guidance on what will constitute a medical emergency as defined under the law? She said, I know some Democratic lawmakers have raised the question on a cancer diagnosis, for example, or the possibility of suicide if the patient has suicide ideation. What constitutes or qualifies for a medical emergency? And I'll be glad to let Dr. Ferris and maybe one of the attorneys kind of tag team that.
I can start, but I will definitely be handing it over to Peter and Liz. So there has been a great deal of debate and confusion among my colleagues who do handle medical emergencies. And certainly my understanding at this point is that even a patient who is actively suicidal would not qualify for an abortion under this law, which is part of the absolute cruelty of this law and not recognizing that mental health is health. But then there's a great deal of confusion. So a lot of doctors are in conversation right now about what exceptions would qualify. And I believe, Peter, you might be able to speak to this, that the amendments in HB 190 did clarify the need that we don't have to wait 72 hours in the case of a medical emergency, which was not clear in the law as originally written.
That's absolutely right. Thank you, Dr. Ferris. So before as SB 20 was initially drafted, it was unclear, it was ambiguous whether providers would have to wait 72 hours to provide care to people going through medical emergencies. And thankfully, because of our lawsuit, the legislature went back and fixed that. However, I do want to highlight that, as we've seen throughout the entire past year since the Dobbs case came down, whenever there's medical emergency language, these ambiguities work to prevent patients from receiving care and to delay care for patients. And I think that's understandable because of the consequences. In a lot of places, there are criminal penalties, and even when there's not, there are often licensure penalties for physicians and providers. And so the medical emergency language does, of course, allow care for some people in the direst circumstances, but it doesn't change the fact that the ban is going to have absolutely devastating consequences for North Carolinians.
I think that it's just really important to say that one of the many reasons that we shouldn't be legislating healthcare is because you cannot boil down into legalese the expertise of a doctor. And we really need to trust our doctors and trust their training to make the best decision for the patient who's presenting in front of them on any given day. And, they asked the example of cancer. Well, I think it depends. What kind of cancer? How aggressive is the cancer? How far along is the cancer? And then after ascertaining all of those questions, doctors are having to call their lawyers and ask and say, are they sick enough? A doctor just earlier this year in front of the General Assembly said that under the current law, current as of today, even with the 20-week ban, that they had a patient and they were going on and logging in remotely to check the patient's charts every 6 hours to see whether or not she was sick enough, according to their lawyers, in order to be able to provide the care that she needed. And it's devastating. We're seeing that, like I said, throughout the South, where there are already instances of people being turned away and not able to get care and then almost dying as a result of that.
We included in our press release, I believe, as well, a link to some articles showing how, because of everything just discussed, bans and restrictions on abortion are contributing to higher rates of maternal mortality, especially in the South, which is even more significant because many states in the South, including North Carolina, already had dangerously high rates of maternal mortality even before a law like this. And Kate Kelly had a follow-up question that I believe Peter is going to answer.
Yep. So Kate's question was whether the aspect about seeing the pregnancy in the ultrasound before providing medication abortion is the only area of the law that's currently enjoined or restrained. So the answer to that is that we challenged several provisions of SB 20, and actually almost all of the individual provisions that we challenged were corrected by the legislature. And so there was no more need for Judge Eagles to correct them because the legislature went back and, I think, as I said at the beginning, cleaned up their own mess a little bit. And so that left this one provision about pregnancies that are too early to actually see in an ultrasound. And for that provision, actually, the law itself was unclear. It was vague as to whether that was actually prohibited. And so under Judge Eagles's order, it is clear that we can provide care to patients at the very earliest stages of pregnancy.
Thanks for that, Kate. We have a question from Rose with North Carolina Health News. Hey, Rose. Is there anything in Judge Eagle's decision that was unexpected? And I'll be glad to pass that to Peter first. And if anyone else wants to jump in after that, feel free.
I think we were definitely encouraged by the decision, and we were also encouraged by the fact that the legislature moved so quickly to pass these amendments. I think that really kind of highlighted that our claims were meritorious. Basically, as soon as we filed the lawsuit, it seems like the legislature started to move and started to correct their mistakes. I think that we were confident about all of our claims and all of our challenges, and Judge Eagles's decision vindicated that.
Anyone have anything to add? Okay.
I can't resist throwing in that
Do it. Yeah.
these inconsistencies and the sloppy drafting that Peter was referencing. That is what happens when the legislature drafts a law behind closed doors without consulting experts and completely evades the committee process, the normal legislative process that we have in the legislature.
Thanks, Liz. Another question from Rose. Is Planned Parenthood South Atlantic beefing up access in Virginia, e.g. near the border? I'll get a start on that, and Dr. Ferris would love to have you add. Rose, we've only had a month to prepare for this particular ban. We are working around the clock to first make sure that our health centers in North Carolina are able to comply with this law and provide care to as many North Carolinians as possible. I know out-of-state patients certainly have been traveling to North Carolina in large numbers over the last year, but I'd like to note that the majority of patients we see are North Carolinians. And we have been working hard to make sure that our health centers are able to continue to care for them as much as we can. We also have a team at Planned Parenthood South Atlantic that we call our patient navigation team. These are staff members who are specially trained to help people navigate barriers, not only in their home state, but in surrounding states, to help them understand the barriers that are in place and how to navigate that, and including helping to secure the resources they need to do that. We want to make sure we can help people get to their appointment, even if it does have to be out of state. And that is certainly a service or department that we have been beefing up over the last year. A data point I learned today is that the majority of patients who we help through this patient navigation team are from North Carolina. So again, I know out-of-state patients will certainly be dramatically impacted by a law like this because of the extra in-person visits. But we are still very concerned about North Carolinians as well. Anything you want to add, Dr. Ferris?
Yeah, I would say that the barrier with the additional in-person visit 72 hours before the abortion absolutely harms North Carolinians. As Molly mentioned at the top, there are only 9 counties in the entire state that have an abortion provider. So everyone practically in North Carolina has to travel, and now they're going to have to travel 2 or 3 times. And we are indeed increasing access everywhere that we provide services. So across North Carolina, Virginia, South Carolina, we are providing as much access as we can within the laws in each of these locations. And we are partnering closely with all of the abortion providers on the ground, and everyone is trying to beef up their services and just try and make sure that patients have access to this critical life-saving healthcare wherever they can get it.
I'd love to take that opportunity to give another shout out to all the healthcare providers out there, all of the clinics in North Carolina and across our region. Many other providers couldn't join us this afternoon. They were, of course, invited to attend, but people are busy, y'all. It's a holiday weekend, and all the clinics are working very hard to see patients, not only today, but get ready for tomorrow. And we have just an incredible network of healthcare providers in this state, in North Carolina in particular. And we all work together really closely because that's what it takes to provide abortion care in a state that's hostile to abortion care. I also want to give a shout out to the Carolina Abortion Fund and other resources that help people pay for their abortion or pay for the resources they need to get to their appointment. We know that bans and restrictions on this care fall hardest on people who can least afford it. And most insurances do not cover abortion care, and most people who have an abortion already have kids. So, for everyone out there has been to the doctor at some point in your life. I'm sure you've had a very inconvenient doctor appointment throughout your lifetime. And abortion care is no different. So we are making sure that people can secure childcare, pay for gas, pay for hotel stays, in addition to just finding and securing an appointment. It's really a web of logistical hurdles that is really hard for a regular person to navigate who is maybe even just learning that their state just banned abortion. Okay, we got another question. Keep them coming, y'all. Rose is okay, good. Okay, we got more coming in. Okay. Another question from Rose. I'm guessing that there are some people who are coming in who don't realize that these changes are coming. What types of patients are they? For example, non-English speakers, low literacy, or are patients pretty cognizant of the law? And what are we doing to educate patients? I'll throw that one to Dr. Ferris.
Thanks, Molly. Yeah, there is a huge amount of confusion. And honestly, that's the goal. That's the goal of this type of legislation. The goal is not to make abortion safer. The goal is to make abortion more confusing for doctors and for patients and harder to access for everyone. So it is absolutely harming everyone who needs an abortion is harmed by this bill. And as with all healthcare, there are groups of people who are more harmed. People who have less financial resources, people who have less medical or internet literacy, who maybe don't have great access to the news to understand what's going on, people with language barriers. Women of color are absolutely going to be more harmed by that. We see that across the South with all of these abortion bans. And so we are doing what we can to make sure that we have information available for patients in multiple languages. We have translator services available through our navigation team while patients are in person and when they're getting their abortion. And it is true that this is always going to harm the people who have the least resources.
Thanks, Dr. Ferris. The next several questions are still healthcare related, so I'll keep you on the line here. We have some questions about other restrictions that are in place besides abortion being banned after 12 weeks of pregnancy. Dr. Ferris, could you give us a rundown of a few that come to the top of your mind? And in particular, Elizabeth's question is about the extra in-person appointments. So let's be sure to cover that. And maybe let's start there, and then we can take the third question.
Sure. It is hard to It's hard to delineate which part of this bill is the most awful because it is full of terrible provisions that are incredibly harmful to pregnant people. And I think it's really, really important to remember anytime we are talking about abortion bans, that pregnancy is not a benign condition. Pregnancy is not automatically safe. As a matter of fact, it is very often unsafe for the pregnant person. And so all of these bans will force more people to continue their pregnancy and put their health and potentially their lives at risk. So some of the pieces that are worst is, of course, the gestational limit. The fact that we cannot do abortions after the 12th week of pregnancy is incredibly harmful when you add additional barriers. As Molly said, we all know how hard it is sometimes just to get in and get a routine healthcare visit. Imagine if you have to do it at a limited number of clinics in a limited number of hours, and you are very, very time constrained. Every barrier we put up to abortion care will push people later in their pregnancy. And now those people will not be able to access care legally in North Carolina. The requirement for an in-person ultrasound and consent by a nurse 72 hours before the abortion is ridiculous, medically unnecessary, and will make it impossible for some people to get this care. So many people can't get time off of work, can't get childcare, can't afford to drive out once, let alone twice. And it doesn't stop at 2 visits. The state is mandating that every patient who has a medication abortion is scheduled for a follow-up in-clinic appointment 7 to 14 days after their abortion. And we know that this is medically unnecessary. There are many, many safe medical ways that a patient can follow up to make sure that her abortion is complete, that she is doing well, and it does not require an in-person visit. But the state is mandating that that appointment must be scheduled. The patient is not penalized if they don't follow up. But the state is requiring that be scheduled. There's also a huge amount of confusing paperwork that we now have to fill out. And that every bit of these things just adds on top of each other to make it harder for doctors, harder for clinics, and much harder for patients.
Thank you, Dr. Ferris. To just, again, answer Elizabeth's question, and I get this one a lot, how many appointments are required? This law mandates that the patient schedule 3 in-person visits. As Dr. Ferris said, the first 2 are definitely mandated. They have to come in person before they can receive abortion care. Then they come in person for the abortion. And this is for a medication abortion, y'all. And then they are required to schedule their 3rd follow-up visit. And again, I need to highlight that this is for a medication abortion, which more than 60% of the abortions provided in North Carolina are medication abortions. This is a very common method of abortion in the state and across the country. Also, the FDA has said that this care can be safely provided over telehealth. The FDA has said that you don't need to come in person at all to be safely provided this care. As nearby as Virginia, folks don't have to come in person at all for a medication abortion if they don't want to. Of course, if you prefer to be seen, absolutely. But if you don't, you can have a telehealth visit with your healthcare provider and be prescribed this medication via telehealth. But in North Carolina, people have to come in person 3 times. Okay, another question for you, Dr. Ferris. From Brenna with Port City Daily. Do you have any guidance on how much information a victim of rape or incest will need to give a provider in order to access an abortion after 12 weeks?
So we are required to have that information from the patient and document it in the medical record. That they do not have to provide proof that they were raped or a victim of incest. And we will, of course, continue, as we always have, to follow all mandatory reporting laws, particularly as they apply to minors. And the issue is that this law is forcing people to disclose this information who otherwise may not want to. It is an incredibly vulnerable thing to tell someone that you were sexually assaulted, and people should be able to access healthcare without having to reveal that information if they choose not to. We obviously want patients to feel comfortable talking to their healthcare providers about all of their medical history. But this law forces them to disclose things that they may otherwise choose not to.
Thank you, Dr. Ferris. Also, as a heads up, I put in the chat a written description of a lot of these restrictions that we're talking about for all my visual learners out there, or if anyone wants to copy and paste. Okay, I've got a question from Ned Barnett. Hey, Ned, long time no talk. Can Ms. Barber, Liz, elaborate on the problems with the way this legislation was drafted?
Sure. So what we have seen, the normal course of things for, how a bill becomes a law is that a bill is introduced and it goes through the committee process. And typically for abortion laws, that means going to a healthcare committee in one of the chambers, then to judiciary, then onto the floor, over to the other chamber through similar committees, and then onto a floor vote, giving a total of 6 different opportunities for people to amend the bill. And amendments can be broad policy amendments, or they can be technical amendments. And this was very different. It skipped all of those substantive opportunities to amend the bill. This started as a bill that had absolutely nothing to do with abortion. It passed through one chamber, went over to the other chamber, was gutted and amended, and ended up in what's called a conference committee report. And so at a conference committee report, the 2 chambers come together, designees from each chamber, behind closed doors. It's just a handful of people, and they come up with yet a third version. So different than the version passed in the first chamber, different than the version passed in the second chamber. They come up with a different version. And usually that's to hash out some technical differences, but the substance of the bill doesn't significantly change, right? It's like, we both agreed on some version. Let's, bring the differences together. The difference is here, they completely gutted a bill. They completely gutted a bill and made it about abortion. And they had already agreed to all of the terms. And we know that because the conferees were appointed one evening, and maybe an hour later, they announced that they already had it and had already signed it. Then it did go through a committee, but that committee, it was only up for debate, because in a conference committee report, it goes back to both of the chambers just for a thumbs up or a thumbs down vote. And so if it had gone through this normal procedure, they would have caught, for instance, that they failed to correct the fetal homicide cross-reference to this section. And so, but for HB 190, where they went back and fixed it, lawful abortion would have been considered fetal homicide. And obviously that was unintended, but that's just sort of one example of sloppy drafting that would have been caught if advocates and representatives and senators had been given the opportunity to really sit down and spend time with the bill before voting on it.
Thank you, Liz, and thanks, Ned, for that question. Our friend Brian has another question for us. Brian?
Thanks. Just elaborating on that, I know this was a rushed process, and after it had been vetoed, there was a public awareness campaign to highlight different portions of the bill through roundtables. And I'm just curious, from the time the bill was vetoed to the time it was ultimately overridden, were there any private dialogues with Republican lawmakers or Democrats to try and get a legislative solution before this lawsuit was filed?
Yes, efforts were made, and we drew some of these impossibilities to their attention. We pointed those out both in a press release and also in private conversations, and they failed to act or to do anything to fix them until after we filed the lawsuit and a hearing was scheduled.
I'd also like to note that there were many healthcare providers, physicians who went on the record with members of the media to say that they had repeatedly tried to speak to legislators about the problems they saw in the bill, many of which are now reflected in House Bill 190.
And going back to the process just for a moment, the leadership of the legislature was very open that they were, at the beginning of session, that they intended to pass an abortion ban and negotiate it behind closed doors. So while it was surprising, sort of the extreme that they went to and the speed at which it moved, they were upfront with their plans that is what they intended to do.
Thanks for that, Liz. I see no questions in the Q&A. Brian Anderson, do you have any more questions for us? Okay.
I'm sure down the line.
Okay. Thanks, Brian. And on that note, with that, we're going to end this press conference. I will stop recording.
Recording stopped.
I have just put Planned Parenthood South Atlantic media office email in the chat. That's the best way to get a hold of us. As you have other questions about this, it's certainly a complex law, and the impact of abortion bans can be very complex. So I'm sure we will have more to talk about in the coming days and weeks ahead. Please do stay in touch and let us know how we can help you with your coverage of this or any other issue. We'll be glad to help you with that. Thanks, Gary, for attending. Thanks, y'all. We really appreciate you making this really quick press conference on a Friday on the holiday weekend, especially. I'll follow up with y'all to give you the recording of this press conference. You can have it for your records and your coverage. But other than that, thank y'all so much for giving this abortion ban the attention it needs in the media. We really appreciate that, and we hope to stay in touch. So thanks, y'all.